Your Honours, ladies and gentlemen, environmental governance, the rule of law, two very controversial, very challenging ideas. To bring them together is perhaps too ambitious, but let me try. First, our point of commencement, I would suggest, is the diversity of interests in the context of environmental governance. There's a whole range of individual and private interests. They relate to locational issues. We're talking about land in particular, but not just land. We're looking at all the natural resources associated with land. So locational issues arise in the context, for example, of urban land, peri-urban land, rural land, native title land. But equally obviously, there's a whole range of conflicting uses and potential tensions here. The whole range you're familiar with. Residential, commercial, infrastructural, agricultural, horticultural, forestry, water supply, industrial activities such as mining, energy production, energy transmission, and ultimately, of course, possibly no use at all if you're looking at it in the terms of conservation. And then, of course, you have the public interests, setting the values, setting the strategies and the policies, affording access to natural resources, controlling activities once access has in fact been granted. These are issues that impact upon the private sector, the private interests, but they're also very much a matter of public interest as well. So there's a whole set of potential tensions and conflicts when we're looking at it in that wide context of environmental governance. Environmental governance, again, is a set of dynamic relationships. We talk about location, we talk about conflicts, uses, and so forth. The private sector, the public sector. But it's all dynamic. It's changing all the time. People's values change, people's aspirations change, governments' values change, their aspirations change. So there are huge, significant economic, social, and environmental challenges. Now, I use these three words very specifically: economic, social, and environmental challenges. When I first started to become involved in environmental law many years ago, it was perceived to be, probably in the 1960s, pollution control, an element of it. But it's huge now in that particular context. It's not just environmental challenges, we're linked into social challenges and economic challenges. That's the first problem. The second issue for us, of course, is the nature of legal challenges in the context of the rule of law vis-a-vis environmental governance. It is of the essence, I would suggest, of environmental governance that the system responds to change for the reasons I've just been mentioning. Whether change is brought about by human activity or by natural events. And one of the consequential challenges, therefore, is whether environmental governance should be the responsibility of the executive branch of government. Another is the function of the legal system that sets the framework within which the executive branch of government operates. A third is the extent to which the judiciary is involved in interpreting and applying the arrangements created by the legislature and implemented by the executive branch. Simple issues, but difficult to deal with. In this way, I would suggest fundamental issues of the rule of law arise. Third, what in fact is the rule of law? We all know the answer to that. I'm not going to go into that in any more detail. There are different views about it, what it means actually in practice. And the examples that I'll have a look at in a moment look at it from that perspective. What's actually happening there in terms of the legislation? So there are different views about what it is. Justice Sales of the High Court in England and Wales wrote this a little while ago. He said there are a number of approaches to the rule of law. Some of it is purely formal, some of it moves towards substance. So the rule of law can be perceived in purely formal terms. It can be perceived as a matter of process. It can be perceived as a matter of substance. The comments I'm going to make this morning relate to the last, a matter of substance, which means getting down to the detail of some of the rules of law so that we can ask the question, are these detailed rules of law in the context of environmental governance consistent with our wider concept of the rule of law? So that's a perception from a judge. Looking at it from a slightly more philosophical perspective, government in all its actions is bound by rules fixed and announced beforehand, etc., etc. Fair enough. Government is bound by the law. But everyone is bound by the rules of law. So it's a question of, in the context of environmental conservation, getting that balance. Yes, government is bound by the law. We are bound by the law. Individual owners and developers of land and resources, they are bound by the law. The issue then becomes relating the rules of law that we're going to have a look at with the wider concept of the rule of law. The issue is whether the rules of the law must, as a matter of a legal obligation, or at least should, as a matter of perhaps a moral obligation, conform to a higher normative standard. What are these higher normative standards with which we're used to talk about in the context of the rule of law? We talk about democracy, we talk about liberty, we talk about natural justice. Two are perhaps particularly important in our context today, in environmental law. One is property. Property is a very elusive concept within the legal system. It's perceived to be a value in itself, as well as an instrument for achieving certain objectives. And as you know, of course, in many parts of the world, property is being built in as a human right or some kind of fundamental right within the system. The other one may be, and this is controversial, sustainability. You'll recall a few minutes ago I talked about the economic, the social, and the environmental challenges. That's sustainability. So in the context of environmental governance, it is perhaps sustainability that is increasingly being seen as the concept that gives coherence and direction to how natural resources and the environment are managed. This is controversial. It's not universally acknowledged, but it is a point from which we can start our discussion. But it is an element of the legal system, sustainability. Let's just pause for a moment and see what the Chief Justice of the Land and Environment Court of New South Wales has said about it. And these are judicial comments. Justice Preston often writes extrajudicially as well, but these are judicial comments. Let's just pause for a moment. He talks about the principles of ESD. They are to be applied. That's a form of a rule of law, isn't it? It's a particular rule of law. You apply these principles. The next point he makes in the second paragraph there, the object of the act. That's looking at it at a very sort of strategic level. The third part he looks at, in relation to the New South Wales legislation, the matters that must be considered. Again, that's a rule of law. It's a procedural rule of law, verging towards substance, but it's not really quite substantive in that sense. And then he talks about the public interest. That is the terminology in the legislation. And as we'll see, there's similar legislation in Queensland to the same effect. And then he puts it all together in the context of sustainable development. Now the important point is, these comments by Justice Preston are formulated as rules of law. They're not aspirational. He's actually saying these are the rules which we must follow. And the point is that these rules perform different functions. Some are strategic, some are regulatory, some are process. And it's a question of in fact putting them all together to see if we can achieve some coherence within the system. It was against this background, let's consider current approaches in Queensland. And I have to be very selective because there is so much legislation on environmental governance. Time permitting, I'll divide it into three. Legislation affording access in the first instance to natural resources, legislation protecting the environment, and legislation conserving ecological values. So let's look at access first of all. I've selected two regimes. The first one, the Land Act. Section 16, interesting. It imposes a specific duty. So I'm being very technical now. A specific duty to evaluate the land with a view to assessing its most appropriate tenure and use. So there's a duty to evaluate, and the objective of that duty is to respond to the question, what's the most appropriate tenure and use in relation to the land? The second obligation, which is slightly different, but it's still an obligation, the evaluation must take account of these various strategies and the object of the Act. So there's a duty to consider the object of the Act. So that's, if you like, a process, an intellectual process, but it's linked to the object of the Act. What are the objects of the Act? There's a lot of not stated objects in the legislation, but two are interesting. Notice it says in the administration of this Act, so clearly this is directed at those administering the legislation rather than the wider public. You think of it in the context of making an application for a leasehold interest in land or something like that. First of all, sustainability. 1994, Queensland Parliament introduced the concept of sustainability into the legislation. It was, of course, just a couple of years after the Rio Declaration, which is consistent with what's stated here. And then evaluation. Evaluation is to be based on the appraisal of land capability. Now, these are quite specific outcomes, objects, if you like, that have to be taken into account in making that evaluation, which is a fundamental duty. So that's allocation in one sense in relation to land. Let me now look at another aspect of allocation, geothermal energy. It's not really happening a great deal at the moment, which is one reason I've selected it. It's may become controversial, but perhaps not quite so controversial at the moment. Again, look at the form of the legislation. The purpose of the Act is to encourage and facilitate safe production. Short, simple, to the point. One object. There are other purposes. Now, think of the distinctive features again. The main purpose is the development of the resource. Other purposes. So Parliament has got a hierarchy of purposes. That causes a problem for the administrators. How are you going to balance these out? There have been very rare comments judicially in this context in Queensland or indeed elsewhere. But if you say one purpose is a main purpose, or the most important purpose, or whatever, then the courts, to some extent, have actually taken that at face value and said, no, Parliament said that, that's it. You know, the other purposes are, you can imagine there we are, minimising land use conflicts, constructive consultation with people, compensation and responsible land and resource management, and encouraging the use of renewable energy. But the two that spring to mind as being particularly relevant in our context are minimising conflicts with other land uses and constructive consultation. Consultation, of course, is a process. Minimisation of conflict is an outcome. But once again, the point that I'm trying to establish is the different nature of these rules. They perform different functions. They're structured differently. Then going on to Section 80 of the Act, so we're becoming a bit more specific now. The Minister may grant an applicant a geothermal lease only if satisfied the requirements in Section 81 have been complied with. So there is a rule which restricts the capacity of the Minister to grant the applicant what the applicant wants. And what does Section 81 says? You've got to have a relevant environmental authority, that is under the Environmental Protection Act, and you've got to have a relevant Water Act authority, an allocation or a permit or a license or whatever it happens to be. In addition to that, you have to have a development plan. And the development plan, of course, includes an assessment of the water, potential for obtaining Water Act authorization, potential structure and other impacts of carrying it out on aquifers. So clearly, there are two levels there of protection, if you like, of the aspects of the environment. One is by way of the restriction on the ministerial decision-making process, and the other is assessment of these in particular contexts when you're dealing with the preparation of your development plan. So there's a hierarchical set of relationships which are designed to protect other interests, notwithstanding that the main purpose of the Act is the development of geothermal energy. Now, that complicates the thing legally, of course, because you're complying with the provisions of the Geothermal Energy Act. You also have to comply with the relevant provisions of the Environmental Protection Act and comply with the provisions of the Water Act. How are they, in fact, related? Now then, so much for access. Let's turn to environmental protection. I'm sure you're all familiar with this. That's its stated object. Again, you start at that point, the object of the Act. It says it's ecologically sustainable development, which it probably is. So the title to the Act itself is inconsistent with its object, if I may criticize the statute. It talks about environmental protection, but it actually is not just about environmental protection. Environmental protection is one element of it. It's all directed at ecologically sustainable development. Now, Section 5. Again, the form of this is very important. It places an obligation upon everyone involved in the administration of the Act to perform the function or exercise the power in the way that best achieves the object of this Act. I've been waiting since 1994 for a court in Queensland to tell us what that means. Nothing has happened yet. The courts in Queensland have not really had much opportunity to get involved in some of these particular issues. I think I know what it means, but I'm not going to tell you. I have to wait until the Court of Appeal tells us in fact what that means. It's clearly an obligation. There's an element of discretion in it, but the question is a court prepared to treat that as an enforceable duty? Ultimately, that's the question. Does it raise a justiciable issue? We shall see, perhaps. Now, that's one aspect of the rule of law context. Then there's Section 6. The request there, or obligation there, is to have regard to the views and interests of industry, Aboriginal and Torres Strait Islanders, interested groups and persons of the community generally. Okay, it's just an obligation to take all these matters into consideration. So it's a process obligation. But you can see how the pattern is emerging as a whole set of interrelated obligations of various kinds, all flowing from the hierarchical relationships in the legislation that we've been talking about. Now then, another topic of contemporary interest, where we're actually thinking of protecting land, and particularly agricultural land in this context. A very recent enactment of the Queensland Parliament. The purposes of the Act are threefold: protect land highly suitable, manage the impacts, and preserve the productive capacity. It's the last one that's probably looking to the future. Preserve the productive capacity of the land. So that's very clear statement of what the purposes of the Act are. And they are conjunctive notices, and. You don't select, you must try and move towards the achievement of all three purposes together. The Act gives us principles. So this is another element of the hierarchy of decision-making that I'm talking about. These are the following principles. And the last one there is productivity. That's the productivity of the land. Now bear in mind, the Land Act itself was talking about the capability of the land to be developed for whatever purpose. So in a sense, this legislation is simply catching up from the legislation that was passed in 1994 about land generally. But here, of course, we do have land which has already been devoted to certain activities. Now, look at the second paragraph there. The protection principle, the first one there, is to protect strategically cropping land, and that, except in exceptional circumstances, doing so takes precedence over all development interests. So there's a parliamentary statement. Give precedence to the protection principle, but of course it's not absolute, except in exceptional circumstances, and they are defined in the legislation in some detail. Now, how is this going to be achieved? Very broadly, through imposition of duties once again. A person must not carry out or allow the carrying out of development that has a permanent impact on the land. Now, that's a general duty imposed on anyone. It's got nothing to do with government. It's a legal rule directly capable of enforcement, but it's cast in fairly general terminology. You mustn't carry out an activity that has a permanent impact on the land. So you go back to the definitions of permanent impact, etc., etc. So the obligation is clear, and it's an enforceable obligation, but it's going to be difficult to do it in practical terms. Coupled with that, there's another one there, section 101. This is coming back to the restrictions not on those engaged operationally with land, but those actually making decisions about what should be happening, in other words, government. The chief executive must consider these various elements. They are obviously specific in terms of the location and so forth, but again, that's a specific obligation. The chief executive must consider. Now, that subject matter of that duty to consider has been somewhat problematic, but the courts, I think, have now recognised, and it's emerging from the jurisprudence coming from, among others, Chief Justice Preston in New South Wales Land and Environment Court, it is a significant obligation, but there's still doubt about its parameters. Okay, so they have to consider that, but you also have to consider this SCL principles, which we looked at before. So you can see this complicated pattern that's actually emerging. Now, two further examples. Aboriginal cultural heritage will not, very important, but I'll just leave you in a sense to deal with it to some extent in your own context. The main purpose of the Act, once again, is to provide effective recognition, protection and conservation. So in a sense, it's conservation we're talking about here. Again, the main purpose, not the only purpose. There are principles. So you see this pattern emerging: objects, purposes, principles, various detailed rules, and so forth. And it's the linkages between all of these that are going to be important in practice. Then there's the process. How do you do it? Ensuring Aboriginal people are involved in processes for managing these particular outcomes. That's a process element of this particular rule of law. And it's supported, of course, by specific duties. This is an interesting one. It's a bit novel in this respect. It's been there since 2003. The cultural heritage duty of care. Now, again, it's imposed upon everyone within the community. A person who carries out an activity. It's not absolute, reasonable and practicable measures only. And the outcome of these, of course, is make sure it doesn't harm Aboriginal culture. And that's supported by a more general obligation: don't harm Aboriginal culture. So you can see the specificity of these obligations, but they're cast upon everyone. It makes, of course, sense. And then our final example, the controversial Wild Rivers Act. Again, it's clear, but this says the purpose of the Act, not the main purpose of the Act. Whether the court would identify a distinction between the two is to be seen for the future. Parliament has said this is the purpose as distinct from the main purpose, or one of a series of purposes. And then there's a provision which we'll look at in a minute. So this provision will apply if you're going to engage in activities or taking natural resources, and these activities will be prohibited under the declaration, which states the application of the legislation to a particular area. So you need a declaration that an area is a wild rivers area, which restricts, of course, the activities. And if you're going to engage in activity which would otherwise be prohibited, you have to comply with this section here. So it operates, in fact, upon restrictions imposed upon the minister. The minister can approve the plan with or without conditions if the minister is satisfied, basically, that you're not otherwise going to contravene, basically, the fundamental principles and the purposes of the legislation. These examples, I would suggest, indicate the emergence of a set of interrelated rules for environmental governance. There's lots more examples. You could look at the Commonwealth legislation as well. And these are, just summarising very briefly, the objects of the legislation, the strategies contemplated by the legislation, the principles upon which it's all based, the competencies created by the legislation, who does what, the restrictions upon the exercise of these competencies, and the various liabilities if you don't comply with it all. These are all directed to some extent at the achievement of ecologically sustainable development. There is no obligation to achieve ecologically sustainable development, but it is part of the system in the way that we've been talking about. So it's an aspect, and there are various aspects through these examples of the formal aspects of the rule of law, consultation, etc. processes, the procedural aspects of the rule of law, and the substantive aspects of the rule of law, all moving towards sustainable development. Although it's the responsibility of the judiciary to uphold the rule of law as one of the principles underpinning our system of government, the judiciary itself is limited by the nature of these particular rules of law to which it is required to give effect. That's a difficult balance for the judiciary to achieve. So we leave it to the judiciary to implement this system through these